Hi, class. Welcome back. This is Professor Watson, and today we are looking at LGLA 2303. So we're talking about personal injury and tort law. Today we'll be talking about Chapter 1. So thank you for being here and thank you for watching this. We're looking at Chapter 1 today, kind of the introduction, and we'll talk about what is a tort. So Chapter 1, I hope you've already read the materials. I have some lecture notes myself that you should find on our eCampus shell, or I'll try to drop them in a link at the bottom of this video in case it's easier for you to get them that way. And maybe we'll try to split this chapter up into two videos to make it a little more manageable, okay? But today we're talking about Chapter 1 in torts, so if that's what you're looking for, you found the right place. I guess a good place to start any personal injury and torts class is to talk about, well, what is a tort? What is a tort? I hope you've already read the chapter by now. Like I said, I hope you already looked at those class notes. But if you haven't, please do so when you're finished with the lecture, or maybe pause and go take a look at them. I'm going to throw those up on the screen from time to time because I think it's helpful. And because honestly, I just use those more than I use PowerPoints. So the question is, what is a tort? Generally speaking, a tort is a civil wrong. Okay, a tort is a wrong. Is a I guess to be more specific and more technical, a tort is a wrong committed by one person or one entity against another. Um, it is a wrong that causes some type of legally recognizable injury, and it is a wrong that the law recognizes that there's some kind of remedy in law or equity. Okay, so that's kind of a lot to pack in there. The short version is that a tort is a civil wrong, or maybe a little bit broader, a tort is a civil wrong for which the law recognizes a remedy. Right, so if you punch somebody in the face and you sue them for damages, that is a tort. That is a civil wrong. I am suing the person who punched me in the face, right? And the law recognizes that that's a wrong and recognizes that I have a right to bring suit for that and recognizes that there's a remedy that I can get. We'll talk about all this today, and then we'll talk about it in much more depth throughout the semester. But that's as opposed to if maybe you called me a name and hurt my feelings, right? Now that may be a civil wrong. You and I may think, well, that's terribly uncivilized, and you shouldn't say things to hurt other people's feelings. But the law doesn't recognize a remedy for that. You can't sue somebody, generally speaking, for hurting your feelings. The law simply doesn't recognize a remedy. So hurting somebody's feelings, not a tort. Punching somebody in the face, a tort. Okay. Um, Thinking bad thoughts about somebody, not a tort. Wrecking your car into their car, that's a tort. That's a civil wrong for which the law recognizes a remedy. Okay. If you look at our notes, you'll see that those remedies, that definition says that the law recognizes remedy in law or in equity. What does that mean? Law or in equity? Well, generally speaking, legal remedies, or what we would call remedies at law, those are typically money damages, right? If you sue someone for money, you are seeking legal damages. But that's not always enough to make the plaintiff whole, right? Sometimes just paying somebody money damages isn't enough to make them whole. And maybe that's not all they need. Maybe there are no money damages, but that doesn't mean there's nothing the court can do. Um, Other remedies we would call equitable remedies. And equitable, of course, comes from equity, and equity just means in fairness. Okay, it doesn't mean that the judge or the courts can do just anything they want. It means that the courts still have to follow the law, but there are equitable remedies, fairness remedies that go beyond that payment of money damages that courts can also sometimes award. So these non-money remedies that a court could award, something like an injunction or a turnover order, those kind of things, telling someone to do something or telling them not to do anything, right? No money changes hands, but that is a remedy that the court can grant in the appropriate circumstances. So we might call that an injunction, right? Be careful. Usually when, especially lay people think of injunctions, We think of injunctions like a restraining order, right? Thou shalt not. Don't do that. You are enjoined from doing this. You're enjoined from doing that. You're enjoined from going there. You're enjoined from saying this. And yes, generally speaking, more often than not, injunctions are negative. But injunctions can be positive, and that is still an equitable remedy. Sometimes the court can issue an injunction ordering someone to do something, a positive injunction. We think of this, if you had your property class yet, we would think of that like a specific performance, right? You have a contract with somebody to sell you their house. They don't want to sell, so you sue them. You don't want money. You're the one with the money. You want to pay them, and you want to force them to sell you your house. The court could issue an order ordering them to sell the house. That would still be an injunctive relief. It's just a positive injunction, and we would think of all of that as equitable remedies. Okay. For this first chapter, maybe let's go over a couple of more kind of glossary terms that we'll be using when we talk about tort and personal injury law. The first is tortfeasor. One word, Tortfeasor, tortfeasor. The tortfeasor is someone who commits a tort, right? So in the law, usually that's if a suit has been filed, that's usually the defendant, right? The plaintiff or the victim sues the tortfeasor or the defendant. Okay, so the tortfeasor is the one who committed the tort. We usually use the term victim or plaintiff for the person who has had the tort committed against them, for the person who has been harmed. So the tortfeasor causes the harm. We don't have tort sufferer. We just use victim or plaintiff for the person who suffers the harm. Okay. Before we move on, I want to point out I guess maybe one or two more things. Number one, there's a difference between a tort, that is a private civil wrong, right, where one person wrongs another, versus a crime. A crime is usually a wrong that is defined by statute. We have constitutional requirements in this country that before you can be convicted of a crime, you have to be put on fair notice. That means that generally speaking, crimes have to appear in statutes. The government has to tell you exactly what it is that you're not allowed to do before you do it, or they can't prosecute you. Okay. Also, crimes are generally thought of as wrongs by one person against society. Okay, one person against the government, one person against the common good. Okay, even when you have a victim. So if I punch somebody in the face and the police arrest me, then the state prosecutes me for a crime. Okay, crimes are always prosecuted by the government. Individuals, even though they may say, I want to press charges or I don't want to press charges, generally those decisions when it comes to crimes are not up to the victim. Those decisions are made by the state, by the prosecuting attorney, by the district attorney, right? Because generally speaking, crimes are viewed as violations of the public order, violations of the public good, even when you violated that public good by punching one other person in the face, okay? That means that there can sometimes be some overlap, okay? If I punch you in the face, that is definitely a crime. In every state in this country, punching somebody in the face is the crime of battery. All right, and what exactly the elements of that crime are? Well, you'd have to go to the individual states. You'd have to look up their criminal law. Typically, that's in like a penal code, right? And you would have to see how that state defines battery. Okay, and you would find that again in the statutes, in the penal code. And if the police wanted to arrest me, if the district attorney wanted to prosecute me, they could prosecute me for the crime of battery, even if you, the victim, don't want to prosecute. It's not up to you because a crime is the government against the defendant, always the government against the defendant. All right. And if the government decides to prosecute me, they're going to want to fine me. They're going to put me on probation. They're going to put me in jail. Right. But how do any of those things help you out? What if I broke your nose? What if you have medical bills and injuries? Maybe you're out of work. What good does me going to jail? How does that help you? Well, sometimes in a crime, in a criminal case, the state can ask for restitution or something like that. But generally speaking, if you want to seek a remedy for your individual, for your private wrong, that's the tort. Okay. And sometimes the crimes and the torts even have the same name. So if I punch you in the face and the government arrests me and they try me and they try to put me in jail, that's the crime of battery. But what about you? You say, hey, I've got these medical bills. What do you do? Well, you could sue me as well. You could sue me individually in civil court. So criminal court, always the government versus the defendant. Civil court is usually two individuals or two entities, right? Two recognized, legally recognized beings. We'll get to that a little bit later on. So that might be a person versus a person, or a person versus a company, or a corporation versus a person, or vice versa. Okay, but those are civil wrongs. Those are torts. Okay, you got to be careful. If you are being prosecuted for the crime of battery, then those elements will be defined in the penal code in the jurisdiction where you're being prosecuted. But what if you want to sue someone individually? You want to bring a lawsuit seeking money damages. Then you would bring suit for the tort of battery. Even though it's got the same name, even though it involves the same conduct in the same jurisdiction, you have to be careful because the civil tort of battery may have different elements from the crime of battery. Okay, the crime of battery is going to be governed always by a statute, but the tort of battery is going to be covered by civil law. And we'll talk in just a minute about where those laws may come from. Okay. Um, One more thing I want to point out, though, is typically speaking, when we talk about contract law, when we talk about a breach of a contract, usually not a tort. Okay, so you have criminal law. That's when somebody breaches the public good or the public well-being. You have tort law, where you have a private or a civil wrong that you're going to bring in civil suit. And then you have breach of contract. Breach of contract, if you've taken a contracts class, generally not viewed as a tort because generally speaking, breach of contract is not viewed as a wrong. Breach of contract is simply viewed as business. If you breach a contract, then you have to pay the consequences. But it doesn't make you necessarily right or wrong. Contract law, if you've taken my contract law class, you'll know that contract law even sometimes recognizes the idea of an efficient breach, saying, hey, it's actually better for everybody in the world if you breach this contract. But if you breach the contract, there may be consequences, but it may not be a wrong. Okay, so don't get those confused. Contract law separate from torts. Torts are about private wrongs where somebody is suing somebody else or some entity is suing another entity for things like money damages or maybe even those equitable remedies. Okay, all right. So if a tort is not a breach of contract and a tort is not criminal law, and we know criminal law is defined by the statutes always, well, where do we find tort law? What is the source of tort law? Well, tort law comes from a couple of places. All right, let's call it 4 or 5. The first source of tort law, the primary source of tort law, is generally the common law. Okay, the common law, meaning those judge-based decisions that have been handed down over time for hundreds of years. Those legal decisions that have been written down and passed along is what we would call legal precedent. Our common law in this country actually predates the first modern Europeans setting foot on this continent. We brought most of it over from England. England had a common law tradition where judges would resolve civil disputes between people. And somebody decided, hey, you know what? It would be nice if we started, resolving similar suits the same way. And so people started writing down these decisions. When one guy was driving along and ran over another guy's chicken with his cart, he sued the cart driver, and the judge said, okay, well, if you ran over his chicken, you owe him, $3, or you owe him a basket of grain, right? And so then the next year, when somebody else ran over a chicken with a cart and they got sued again, somebody came in and said, hey, judge, you should do the same thing you did last time. One chicken is equal to, $3 or a basket of grain or whatever. And so they started to write those decisions down so that there could be some consistency. That became the common law. And the common law expanded into the definitions of certain torts, and we brought those with us when we came to the Americas. And that is what our common law tradition is based on. Now, obviously, we have several hundred years of court decisions here in the United States that have expanded on that and adopted that and adapted that and modified it and made it our own. Nonetheless, that's the common law. The common law is these court-made decisions um, about how the law should work. And generally speaking, torts and tort law and personal injury law is governed first, primarily, not solely, but primarily by the common law. So if someone comes into your office and they've got a problem, they say, "Hey, somebody hit me with their car. Can I sue them?" And you need to research that. You're going to have to say, "Well, give me just a minute. I need to know where the law is. I need to know where I go to see what you would sue somebody for if they hit you with their car." And that's going to fall into torts, and you're going to need to look at the common law, those judge-made decisions. Okay, that's not the only source of tort law. Your book points out that even constitutions can be a source of common law. I'm sorry, a source of tort law. And yes, I said constitutions, plural. Remember, there's not just one constitution in this country. There's 51. Each state. Well, we certainly have the U.S. Constitution, right? That's a formative document, a document that created the United States, right? It's a setup document. It's a big picture document, generally speaking. But in that Constitution, there are some rights that Constitution gives to individuals in the United States. And from that, we've developed the right to sue other people for violation of those rights. Okay. And like I said, every state also has their own constitution. There's a couple of states, mostly up in New England, who don't call it a constitution, but it's the same thing, right? We have roughly 51 constitutions in this country, and constitutions, while generally speaking, these are large formative documents that create the government. They do occasionally create rights, which can be the source of tort law. Okay, so first source of tort law is common law. Second source would be constitutions. The third source would be statutes. Statutes probably a more common source of tort law than constitutions. Statutes are those laws that are passed by legislatures, right? They're usually brought up in the legislature. They have to pass the legislature. If you're in a jurisdiction with a bicameral legislature, right, a House and a Senate, it has to pass both. Then it goes to the chief executive. If that's a federal law, it goes to the president. If it's a state law, that goes to the governor, right? And then the chief executive signs it into law, and then it becomes a statute. We have statutes that cover all kinds of things, right? Those criminal laws we talked about earlier, those are covered by statutes. We have a whole ton of statutes that don't have anything to do with tort law. Statutes that, set up agencies and departments and tax rules and all those kind of things. But we also have some laws that set up private rights, right? Rights that individuals can sue other individuals for, or one entity can sue another entity for. So those statutes can also be a source of tort law. Statutes aren't the only source of statutes. Constitutions aren't the only source of tort law that might come from the government. There is another form we would call administrative law. Okay, administrative law. Administrative law are rules and regulations. They're not statutes. Statutes were passed by the legislature and signed into law by the chief executive. Regulations are usually rules that are passed by agencies or departments, right? These are agencies or departments that were created by statute, that were created by the legislature. And then when the legislature created that department, or agency, the statutes gave that agency or that department some right to make rules and regulations, okay? And so occasionally those rules and regulations can also be a source of tort laws. Those would be agency rules or agency regulations or department regulations, all right? Your book mentions one more source of tort law, and I want to make sure to clarify. Your book mentions restatements, okay? Specifically, in this case, the restatement of torts. There are other restatements. There are restatements of contracts, restatements of agency. But what is a restatement? It is important to understand that a restatement is not a primary source of the law, okay? Common law, those opinions written by judges, that's a primary source. That's straight from the horse's mouth, right? Constitutions, statutes, even regulations are primary sources of law. That's where the law comes from. Secondary sources are sources that don't create the law, but maybe help us find the law or help us understand the law. Okay, so it's important to recognize that a restatement is we would call a secondary source. So is it a source of common law? Okay, but not a primary source. It's a source that helps you find the law. All right. But what is the Restatement of Torts? The Restatement of Torts is a collection of legal principles that was first put together and published by the American Law Institute. Okay, it is a scholarly document that was put together by judges and lawyers and legal professionals and academics who looked around the country and they said, we have this common law tradition in torts, right? That we inherited from England, but that spread across the United States. And each jurisdiction and each state, sometimes those laws can change a little bit. Those laws can be a little bit different. So the restatement set out as an academic work to try to collect what is the law, what is the common kernel of law that all the states agree on, right? What are the general principles that we all recognize as tort law in this instance, right? And they published that in a book, and they did it a long time ago. And they have regularly revised the restatement. And when those revisions have gotten long enough, have gotten extensive enough, they've actually reissued entirely new publications. So, like the Restatement Second and the Restatement Third. That's where they completely replaced the books with a whole new series. So, what the restatements do is they basically say, hey, we've done the research for you. We've looked at the common law, and here are what we believe are the generally recognized common principles of tort law. Okay, it's an extremely well-respected document, a set of documents. It's a multi-volume set, kind of like an encyclopedia, right? Not quite so long, maybe 4, 5, 6, 8 volumes, depending on which edition, the restatement or restatement second or the restatement third. It's extremely well respected, it's extremely well researched, and it's extremely well maintained. Okay, so is it the source of law? No, not the primary source. But if you can't find any other source in your jurisdiction, maybe your jurisdiction has never addressed this issue before, and you go to the restatement and you find that the restatement has addressed this issue, then even though it's not the primary source of law, the courts aren't going to be forced to follow it. It is nonetheless extremely compelling. Okay, it is extremely well respected, and if you don't have any other law in your jurisdiction and you cite the Restatement of Torts, that is liable to win the day. Okay, most courts, most Supreme Courts are likely to follow the restatement if there's no other law. All right. Additionally, the restatement is an excellent secondary source. So if you're not sure what the law is, the restatement is a great place to start. So if you're a young professional and somebody comes into your office and they say, hey, somebody hit me with my car, hit me with their car, can I sue? And you don't know, one of the best places to start your research would be with the restatement. Okay, it's organized by topic. It starts at the broad, it narrows down to the little, and it tells you what the generally accepted principles of law are across this country. It will also cite you to resources in each individual state or each individual jurisdiction. And in addition, if there's any difference in your jurisdiction, the restatement is usually very good about saying, but see Oklahoma, where the law is a little bit different, and here's the case. Or, but see Texas, where there's a statute that makes the law a little bit different. Okay, so the Restatement of Torts, not a primary source, but a secondary source of tort law, and an excellent resource if you need to do research. All right. So that's generally speaking where we find the law on torts, and we'll talk about this a lot more over the rest of the semester. But for chapter 1, generally speaking, they get you an idea of where we look to find the law. Okay. But why do we have tort law? What is the public policy behind having tort law? Why do we even have it? Well, it's worth understanding that this is a nation of laws, right? This is a nation of courts. We don't go out to Main Street and solve our problems by strapping on our 6 guns anymore. We don't have to do that because we are civilized, because now we have a civil court system that generally speaking is open to everyone to resolve their disputes. If you have a dispute against someone else, you don't have to take justice into your own hands. You can take them to court. Now, you may not like the system. It may not be the best system in the world. It may not be perfect, but it is the system we have, and it is better than many others, like biggest guy wins or strapping on your 6 guns and going down to Main Street, right? So the point of civil law is to resolve those civil disputes that people have in a more efficient, in a more civilized way. Okay. Generally speaking, the goal of civil law, if the law determines that someone has been wronged, then the goal of civil law is to make the plaintiff whole. Okay. It sounds cliche. We say it all the time, but that's a cliche to remember. The general goal of personal injury and torts law is to make the plaintiff whole, not make the plaintiff rich, not make the plaintiff's lawyer rich, but to make the plaintiff whole. If I punch you in the face and I do $100 worth of medical, and you have $100 worth of medical bills, then you're entitled to sue me for $100 worth of medical bills because that makes you whole. You don't get to sue me for $1 million. Put an asterisk next to that. We're going to talk about punitive damages later in the semester. Okay. But would $100 make you whole? In addition to your medical bills, you had some pain and suffering, right? I mean, how do I compensate you for that pain? I can't take the pain back. I can't take it away. Well, the court can. It's an imperfect method, but the court can award a value to that too, right? So here's $100 for your medical damages, and then your pain and suffering. It was just a punch in the nose, so we're going to call that $1,000, right? So that's $1,100 are your compensable damages. Not $50 million to make you rich, not $50 million to punish Watson for punching you in the face in the first place, but the goal is to make you whole. Again, put that asterisk in your notes. Punching somebody in the face is an intentional tort. Intentional torts can lead to punitive damages. We'll talk about that later on. But we're going to get into negligence, right? If I hit you with my car, right? Not an intentional tort. Theoretically, I mean, if I hit you with my car on purpose, that's an intentional tort. But if I accidentally hit you with my car and I do $1,000 worth of damages to your car, and you're not injured, you don't have any pain or suffering, then what you can sue me for is $1,000 because that would make you whole, right? Not about making you rich, it's about making you whole. And that is the primary objective behind tort law. Another often recognized purpose behind tort law is we would call it allocating or distributing the risk, right? If somebody is going to take a chance, right, then we're going to make them pay if there's any injuries, right? If somebody decides, well, I'm going to try to jump my bike over your car, well, they're the ones who decided to take the risk. If they don't make it and they run into your car, it's not fair to make you pay the damages. We should allocate that risk to the person who made the decision, right? So allocating risk or distributing losses or distributing responsibility, right? Making people responsible for their own actions. That is another purpose of tort law, all right? Criminal law, similar, right? We have similar policies under criminal law, but under tort law, that's one of the primary purposes. And then the last would be deterrence and punishment. Okay, yes, the general goal of tort law is to make the plaintiff whole, not to make the plaintiff rich. But occasionally, in limited circumstances, we can get things like punitive damages, where the goal is actually not just to make the plaintiff whole, but to punish the defendant and to deter other people like the defendant from ever doing that again. Okay. Sometimes that deterrence just comes from making them pay for the damages they caused, right? But we'll talk later in the semester about intentional torts and punitive damages. That's when the court can actually award damages. The purpose is not to make the plaintiff rich. Sometimes they do, but the purpose is to deter the defendant and deter other people like him or her from doing that again. Okay, so those are the main purposes of tort law. All right, speaking of intentional torts, the next part of the chapter starts to talk about the types or the categories of torts. And so I tell you what, Let's stop the recording here to make it manageable. And when we come back, we will pick up with categories of torts from chapter 1. All right, see you there. Thanks.